Welcome to the I Got Fired podcast, a podcast for people who've been fired or afraid that they might be. I'm Tom Spiegel, founder of the Spiegel Law Firm and host of this podcast. Little disclaimer, if you need specific legal advice about your case, then you should hire a lawyer. This is general educational advice that can be used to help you as you navigate the legal process. But if you need actual legal advice for your case, then you should hire a professional. Also, in this episode, as with the last one, my camera is not working, so you don't get to see my pretty face on YouTube. But if you're listening on the podcast channels, then you may not care anyway. So this is the final in our series on mediation. And in this final one, we're going to talk about private mediation. So as we talked about before, the general mechanics of the mediation session are going to be the exact same no matter where you are. They're all going to be confidential. Nothing that happens in mediation can be used in an ultimate court case. What's going to happen is the mediator, whoever it is going to come in, make an opening statement about confidentiality and how the mediation is going to go. They're going to give the parties, and by that I mean you, the employee, and your former employer, their attorney, going to give both sides a chance to make an opening statement, which, as we discussed in the first episode, you may or may not want to do. And then they're going to separate parties into two different rooms. I mean, it's usually nothing fancy. I don't care if you're in a court or with a private mediator, you're just in an office building at a conference table, and there are, you're sitting conference table with your attorney and whoever you bring with you, and the mediator will come in and talk to you and your attorney, and then they'll leave the room and go talk to the other side. And how long that takes, it may be sometimes an hour or more where you're sitting in that room kind of by yourself or with your party, just waiting for the judge to come back. Again, sometimes it can be quicker than that, but it doesn't matter, where, if you're at the EEOC, if you're with a judge, with your private mediator, that's how it's going to work. So what is private mediation? So private mediation is, as it sounds, that is where you hire someone whose job it is to mediate cases to help try to reach a settlement. And there are any number of private mediators out there. There are a couple that are well known, like basically big companies, and this is what they do, is provide private mediators. And the really beneficial thing about it is often they will have retired judges or lawyers who are well known in the field for whatever your case may be. So think about that. I mean, you're having mediation with a retired judge who, let's say, had been on the bench for 20 plus years and heard maybe 100 or more cases like yours. And similarly, with an attorney who's been doing this for decades and really knows the field. So it's a very powerful forum to get your case settled. And it's available at any time. So unlike the EEOC or with the court, there's no particular time frame for it. You can hire a mediator at any point. Now, again, both sides have to agree to this. That's not, with a private mediator, it's not mandatory. Both sides have to want to mediate it. Typically, it will happen after a case has been filed in court. Again, that doesn't have to be the case, and particularly if both sides are really motivated to settle. If the dollar figures are really big, then you might get, your employer to agree to private mediation before there's even anything filed. But in most instances, the case has proceeded long enough that you've gone, if it's the type of case that has to be filed at the EEOC, as most discrimination cases are, you have gone past that, you will have filed in court, and then mediation will happen sometime after that. One thing about private mediation that is different than other kinds of mediation is it's not free. So if you're with the EEOC or you're in court, then you don't have to, you're not paying the judge, you're not paying that EEOC mediator. There's at no cost to you. A private mediator is somebody that both sides hire. And, it can be a little pricey. Most of these mediators are very experienced. It can be $500 or more an hour that you're paying this mediator for. So, it's not uncommon for mediation to cost, anywhere between $5,000 and $10,000 to have a day of a mediator's time. Who pays for that? Usually, both sides will split the cost. In employment law, I have seen where the employer will agree to pay the entire portion of it. Another way to structure it is to say both sides will split the cost if no settlement is reached, but if settlement is reached, that the employer is going to pay for that out of its pocket. So that's one of the big differences is these mediators are on the clock and they're usually well worth the money. One similarity between a private mediator and a mediation before a court is they're going to come in with a lot of information. So, of course, if you've filed your case in court, you're gonna send them whatever's in the record, and by that I mean anything that's been filed. For example, your complaint for the employee, the answer from the defendant. If there's been any discovery passed back and forth, that'll be given to the mediator. And the private mediator is also going to request on their own that each side provide him or her with information about the case, with a summary of the case, where parties stand on negotiations. And again, each side provides this to, the other side, to the mediator. It's confidential. The mediator is not going to share this information with the other side, so you can be a little more candid than something that you would file in court. So this private mediator, like mediation in court, is going to walk in there with a binder full of documents. Now, one thing that is slightly different between a private mediator and the other mediators is they are perhaps more than any other motivated to get this settled. That's their job. I don't know, but I suspect particularly with these bigger mediation companies, like, they've got to report like what their success rate is. There's no, they are successful when they are able to resolve a case. And so they really are going to go the extra mile. Another difference that you'll typically see, it's certainly different than at the EEOC and possibly different from what's going to happen in a court, is that often the mediator, because they're so motivated to get this done and because they're experienced, right? They've seen these cases many, many times. They're rarely going to be surprised by what you have to say. And they have often, particularly if they're an attorney who's really well known in the field, they've represented many clients in these mediations and they know how it works. And so the mediator will often have a call with your attorney before the mediation even happens. And what they're looking for is like, hey, let's talk turkey. Where are you really on this case? And, kind of let me know what I need to be prepared for. For instance, let's say defense counsel, your former employer's attorney, let's say this is an insurance case and they've got an adjuster they've been working for and they've been having a hard time getting in touch with the adjuster or getting the adjuster to take the case seriously. That's something that the attorney might share with the judge and say, because the judge, this is not going to be, the judge has seen this before. And so for that attorney to say, look, I haven't been able to get my insurance adjuster to really play ball here or pay much attention to this case. When we come into the room, this is really going to be the first time they've really thought much about this. I think this case should be settled, but I'm not the one writing the check, right? That's the kind of conversation that, defense counsel might have with the mediator. So the mediator knows the real deal walking in the room. And on the other side, for you, the employee, your attorney may share some very candid information with the mediator. For instance, your attorney might say, I really think this case could settle. My client has insisted on this really high number. As I have explained to my client, I don't think that he or she's going to get that at trial. The damages just don't support that number, but nevertheless, that's what my client is stuck on. So then the judge knows, okay, I need to come in and talk turkey to this attorney's client, because that happens all the time. And if you're listening to this and if you're the client, you need to know that attorneys who handle these cases have seen a lot of them. And it's certainly not uncommon for people, former employees to come in and want to be, of course, it makes sense. They want as much as they can out of this case. And maybe they want $250,000. And, that's really in a fair world what they would get, because that's how much damage has really been caused to them. But the attorney's looking at it and saying, you can't even get those damages in court, because they're caps, because juries don't usually award this much, but any number of factors that may affect what your case is worth. And there'll be just a difference in an opinion. And as an employee, it's your case, right? You can't be forced to settle it, even if the lawyer, thinks you're way out of bounds, even if the judge thinks you're way out of bounds. So it's your case to settle. So, the lawyer can't force that, and he or she doesn't necessarily want that. But I've certainly had it where my own clients are like, I think my case is worth $250,000. And I'm like, I think you'll be good to get high six figures. Low six figures out of this. And the risk you have of going to trial is that you're going to lose. You're going to come out of here with zero, and you're going to have to pay some costs for the other side to add insult to injury. And my client to, just kind of stick to his or her guns and say, I think it's, for whatever reason, I think it's worth $250,000. And, you go into mediation with that posture where the attorneys thinks it's evaluates it at low six figures and the client's at $250,000 or higher. And that's information that your attorney will share with the other side. And you want that, right? Because remember, this private mediator has no say over your case, right? If it's particularly been filed in court, they're not involved. They can't be. They would never be a witness. They're not providing a statement to the judge. Like, there's no downside to being completely candid with this private mediator. And the reason they're having this preliminary call is because they want to walk into the room knowing kind of where everybody is. Think about coming into a Thanksgiving meal with a friend's family. Well, you're walking into a room where there are months, at the very least, maybe years, sometimes decades of history. Everybody in the room knows who drinks too much. Everybody in the room knows who's, a MAGA supporter is going to talk about it at the table. Everybody in the room, knows who hogged the mashed potatoes. But you as a guest coming in, you don't know the lay of the land. And the mediator's trying to get a sense of that. Like, okay, when I come to this Thanksgiving table, of course, it's not Thanksgiving table, but when I walk into this room, I need to know not only where the legal important factors are, but I need to know what the personalities are. And you want them to know that because, again, you're paying top dollar for their very capable minds, and you want them to come in a posture, as best able to settle this case as they can. So before you even walk in that room, you've got the mediator who has gotten a lot of information about the case. They've had usually a confidential conversation with your attorney or with you if you're a pro se, but hopefully at this point, you have an attorney. I would say certainly if you're before a private mediator or you're before the court, if you're pro se or you've been handling the case yourself, it makes good sense to go ahead and hire an attorney, even if only just to appear if you had mediation. You're going to more than likely make your money back on that. But anyway, so the private mediators had this confidential conversation with both sides. They've gotten all the information that they can in the case, and they're going to read it. Again, at the EEOC stage or the administrative body stage, so we talked about, man, they've even paid attention to your case. They've got at most a few pages of information. They're really not walking in there knowing a lot about the case because they can't. There just hasn't been that much developed about the case. If you're in the court stage, you have mediation before a judge, they're going to have some of this information. Most of the time, the judges will read it and really pay attention to it. But as we discussed, judges are people too, and sometimes they're prepared and sometimes they're not. They may not really have dug into it. But a mediator, remember, for their own stats, they want to get this case settled. And because they're getting paid for it, they're going to come in prepared. They're going to have this confidential conversation. They're going to have reviewed whatever submission they've asked for from both sides. Again, this is not information that's shared with the other side. So they're going to kind of know what the lay of the land is, and they're going to have read, for the most part, every piece of paper that has been provided to them. So you're walking in with somebody who's a pro, who is in as best a position as possible to get this case settled. And that's why people hire private mediators. It is really, if you're going to get the case settled, it is the best chance to do that. Now, again, you got to have both parties in agreement, right? You can't force private mediation. You've got to have both sides that are willing to do it. And sometimes they're just not. I've had a number of cases as I have attorneys in my office where a defense counsel is like, no, we'll see you in court. And often that's pre-summary judgment. If the case has gotten past summary judgment and you're looking at a trial, often they'll be a little more, they're a little more amenable to having private mediation. But again, not always, and you can't force that. So usually only happens when both sides are willing to do that. As an employee, this is something that you need to be talking with your attorney about, even though it's available. Sometimes both sides just aren't thinking about that because they're hot and heavy into the case. They've got other matters going on. Whereas, if somebody brings it up and says, I'm really interested in private mediation, particularly on the employee side, if you're like, okay, I'm willing to pay half, which can be good money spent. Let's say the half is $2,500. and your case is worth, let's say, even 50,000, certainly more than that, the math is even better. To pay 2,500 to get your case settled and get a check written, to avoid a trial where you've got a decent chance of losing, and at the very least, it's going to take a lot of time. Just a little aside, I'm not saying that you always have to settle at mediation. I mean, there are some times that it's worth going to trial, but you got to be sober about it. So my point is that as an employee, you can be raising this with your attorney and saying, hey, when can we consider private mediation? Let's float this with the other side. And again, if what's getting it done, it means that you pay half of it, that's something you could seriously consider. So anyway, day one, the private mediator walks in and has had this confidential conversation with both sides, has read whatever submissions both sides have submitted, has read every piece of paper in the case, is coming in there with years, if not decades of experience. And then the mediation is going to proceed like all mediations do. There'll be an opening, the judge will kind of the mediator will give their opening statement about how everything is confidential, how things are going to work. And then it proceeds just like every other mediation. Both sides have an opportunity to make their own statement with everybody in the room. And then everybody divides up. You'll go in your separate room with, whoever's with you and your attorney. The employer will go in their separate room, and the mediator will, shuttle diplomacy back and forth, just like every other kind of mediation. I will say, we talked about in the first one, the strategy of whether or not you make an opening statement. One of the things that a private mediator might do, that's something that'll be discussed before you even walk in the room, right? Because the private mediators know what the strategy is about whether or not you want to make a private, each side wants to make a statement in front of the other one. And sometimes, you'll discuss that with the mediator before you walk in the room. So that may be decided before you ever even get in there. But regardless of whether there's a statement made or not, both sides have then been divided into different rooms, and the mediator will go back and forth. And as with a judge, the benefit of having a private mediator is they're going to, remember, they have no reason to hold anything back. They want, if possible, to get your case settled, and they're going to be brutally honest with both sides about where this mediator thinks the case is, and they should be listened to because, again, if they're a retired judge, right, they've decided these cases. If they're a really experienced practitioner and maybe they've handled a dozen or 100 of these cases, they have seen this movie a bunch of times. And again, nobody has a crystal ball. As we talked about in the last one, what's on paper can be different than what happens in a courtroom when you get people on a stand after they've sworn to tell the truth. So I'm not saying that it's a done deal and that the mediator is always right, but I'd say they're within 90%, right? They're within 90% of being able to tell how this case is going to turn out. So whether it's you, the employee, or whether they're talking to your former employer, they can move the needle, and it's certainly in a way that an EEOC mediator cannot, and often in a way that a judge, not that the judge can't, but they are more in the weeds than the judge is and kind of know the personalities because they spent their time studying it. So they're going to walk into the room and tell you, kind of how they evaluate the case, and they'll go back and forth. And as with any kind of mediation, they'll share details, right? They'll say, well, look, I've been pushing the other side. I'm picking numbers out of the hat here, but I'm pushing at the other side. They're at 100,000. I think that they'll put more on the table, but it's not going to be 200,000, right? Or it's not going to be 150. And so they'll give you little details. And that's true of any mediation, less true in the EEOC, but it's certainly true with the judge, where they will give you some details. Again, they're not going to, if you ask the mediator not to share information, they won't with the other side. So they're going to honor that confidentiality. But right, each side is sort of playing a little bit of a poker game, and the more little bits of information that each side can get, the more likely that they're going to get the case settled. So again, let's say the last offer is at 100,000. The mediator walks in and says, I think they'll put more money on the table. Are there any more details you can share with me? Anything that might help us move the needle. And again, this is a place where it's important for you to know kind of what non-monetary factors are going to be important to you. For example, are you willing to sign a non-compete, or do you not want to not sign a non-compete? Or what kind of reference you're going to get really important to you, or is it not important to you? Because those are places where you can sort of play those cards, like, okay, their last offer is 100,000. You told us that, you don't think, you think they'll put more money on the table, but not come up to 150. Let's put, let's try. Let's put you don't have to listen to what you have to do exactly what the mediator says. You can say, hey, let's try. Let's put 160 on the table, and I'm willing to sign a non-compete. So put that out there, 160, and I'll sign the non-compete, knowing in your head that maybe you'll accept 140. And so then the mediator goes back into your former employer's room and talks to their attorney and everybody there and says, look, this is where we are. This is another factor we want to put in here. They've countered at 160. I'm just again pulling numbers out of the hat. Let's say you were at 200 before. So you're moving down. You're making a good faith. They're down to 160, which is a big jump from them. I think you should take that as a good faith. They want to get this settled, and the employee's willing to sign a non-compete to make sure that they're, no kind of threat to you, employer, but they're at 160. And that's how the game goes. And maybe the employer says, oh, okay, well, that is something that's a factor to us, like non-compete is important, so we'll come back at 140. And then the case settles at 150. Again, these are just hypothetical numbers. So that's how private mediation works. It is somebody that both parties hire. They're going to be a pro. They're going to come in of all three types of mediation, the most prepared, the most ready to get this case settled. And then a final difference is, unlike EEOC and typically even with the judge, once you walk out of that mediation room, if the case hasn't settled, it's done. Like you're going to trial. There's not going to be a lot of back and forth. It can be if both sides are really close. And let's say you just weren't able to ink the deal because everybody's tired. You'll get the judge on the phone afterwards, to try to get the case across the finish line. But that's not always the case. Usually, once you walk out of that mediation, if it's EEOC or a judge, it's over. Unless the parties settle it on their own, which of course you don't have to do it in mediation. The parties can do it. Your attorney and with the other attorney can settle it on their own. But in terms of formal mediation, it's over. And private mediation, they'll often stay in the game until it's either settled or it's just both parties like, forget it. There's no way we're settling. I had a case, a sexual harassment case a number of years ago, and there was a pretty strong case, and we had a private mediator, very experienced attorney, had a day of mediation, the shuttle diplomacy, and we got close, but we just couldn't get it done. And that mediator, he called me, he called the other side. I mean, he stayed on it until we were finally able to get it settled. And I think without his efforts to kind of, work both sides, even after the formal mediation was done, I don't think we would have settled the case. And we got a good settlement for it. So a private mediator, again, they're going to be like a dog with a bone. They're going to work on this case for as much as they can, maybe even after parties leave the room, to try to get it done. Again, nobody can force private mediation. Both sides have to agree to it. But if you can get it done, that's usually well worth the money. If you walk out of that room without settling the case, then it just can't be settled, usually. And at the very least, you're going to know a lot more about the other side's positions, and you're going to have had a really good viewpoint from an experienced judge or experienced attorney about what they think your case is worth, which can be valuable in its own right. So I hope that has been helpful. That's the end of our series on mediation. Mediation is a good thing. Most cases get resolved before trial, if not at mediation. So it's really something you want to be prepared for. You don't want to take it lightly. And as an employee, you want to make sure when you walk in that mediation room that you know kind of what your number range is and what the non-monetary factors are. Again, I keep beating that drum, but I've seen it happen a bunch of times where both sides get in a room, everybody's focused on the money, they get the money resolved, and then the fine print comes out in the settlement agreement, and there's some language in there that you don't like and you're not willing to sign for at that price point. So it's better to know that when you go into the mediation, and it can be a strategic advantage to you because there can be important points in the mediation where everybody's close to settling, and if you can put something else on the table, particularly a non-monetary factor, it can be enough to get things done. And sometimes attorneys, because they're busy or for whatever reason, aren't going to be focused on that. And so it may be incumbent on you as the employee to really be asking your attorney before you walk in that room, hey, what's the settlement agreement going to look like? What factors do I need to think about? Like, what about non-compete? What about non-rehire? What about a reference? What about non-disclosure provisions? And if you ask your attorney, they're going to know these. They're going to have had experience with them, and they can have a conversation with you about, what's important to you and what are you willing to sign and what are you not willing to sign. And again, private mediators are usually pretty good about that. They're going to have these factors in mind, but not always, and certainly not the case with the EEOC, and sometimes in mediation before judges. So it's going to be important for you to walk in there understanding what's important to you and what the fine print's going to look like, and to use that to your strategic advantage. So have that conversation with your attorney before you walk in the room. The more prepared you can be, the more likely you're going to get a settlement agreement that is favorable to you. And finally, as with any kind of mediation, certainly private mediation, these can go long. So be prepared. I've had mediations go well into the night, which can be well worth it if you're getting, the case settled, but have a good night's sleep. Come in there with your coffee or whatever it is that you need to get yourself through the day, energy bars, because it's no fun to be at mediation table at 11 p.m. and you're just worn down and you end up agreeing to something, in the dead of night because you're tired, that when you wake up in the morning, you wish you hadn't. So come in there physically and mentally prepared for the long haul, and that can be another strategic advantage to you. So that's the end of the series. Hope you found it helpful. I urge you guys to sign up for the Career Rocket newsletter. It's free. You can find the link in the show notes, and it's where you get information in your email box on a regular basis that's going to help you not only know how to protect your career, but know how to get foot forward in your career, how to get your career to the next level, whether it's, how to write the best resume, how to negotiate for a raise, how to advocate for remote work, if that's what you want, how to succeed in remote work. That's just some examples of the topics that we cover. And then, of course, unlike some other career services providers who are out there producing great information, if you need it, we've got the lawyers, and we can give you that piece too, what the legal strategy and what kind of legal things you need to be up to date on. So sign up for the Career Rocket. It's free, and you can find the link in the show notes. Appreciate you listening. And until next time.